Presumptions are facts which are automatically accepted by the court without need of proof, that is to be read together with burden of proof. Where it applies, it will relieve the party who can rely on the presumption from proving that particular fact, as in the court.
Our first presumption would be the presumption of fact in publication. For this presumption, the principle for this law can be found under Section 114A, subsection 1, 2, 3, and 4 of the Evidence Act. Stated in the Act, this presumption is that any publication where the owner's name is written is presumed to be the owner and can be liable for any published picture, content, or name on the published publication. Such examples, a track IP on any computer is presumed to be the owner of a publication unless they can prove the contrary. In the Act, publication includes picture, statement, and audio. There are two elements that are needed for presumption of fact in publication. Example of case law use is Ahmad Abdul Jalib vs. PP 2015, which also includes the application on the criminal case law. Commentary. The law can easily presume that ownership of publication can be through the author's name or track device using the publication, and it can be liable. However, incidents like spoofing or blackmailing may happen towards innocent people, and a thorough investigation should be done to prevent this from happening.
Next, we have Presumption of Death, Section 108, Evidence Act, 1950, known as Presumption of Death, means that a person can be presumed dead if he has not been hurt by 7 years. In the case of Lawsuit 1 versus Hong Leong, the deceased had been missing since 12 December 2002, and the plaintiff then obtained a High Court order pronouncing that the deceased was presumed dead, and it was proved that the deceased had not been hurt for the past 7 years. The presumption of death can be used when a person is missing for over 7 years, just like in the case of application of Tay Soon Pao. As for the commentary, though presumptions are classified as presumption of law or fact, it is relatively very difficult to distinguish between both of them, as the classification of the presumption into the presumption of law or fact does not imply any alteration in the legal effect of presumptions.
Created using Powtoon.